Good day, everyone, and welcome to Media Laws and Ethics. Before we start, I'd like to enumerate our learning objectives for this subject. At the end of the lesson, you will be able to understand the importance of communication in society and know relevant laws affecting free press and mass media, limitations to freedom of expression, among others. Now, what is mass media? Mass media actually refers to communication devices which can be used to communicate and interact with a large number of audiences in different languages, be it the pictorial messages of the early ages or the high technology media that are available today. One thing that we can all agree upon, though, is that mass media are an inseparable part of our lives. Entertainment and media always go hand in hand, but in addition to entertainment, mass media also requires to be an effective means of communication, spreading information, advertising, marketing, and in general, of expressing and sharing views, opinions, and ideas. Now, there are several types of mass media as follows. The print media, such as newspapers, magazines, booklets, and brochures, billboards. And then we have the broadcast media, such as television and radio. The narrowcast media, such as film, cinema, and cable. The new age media, such as internet, the electronic books, and magazines, blogs, and vlogs. Now, the next question that we will answer is the question, what is law? Law, according to dictionary.com, is the principles and regulations established in a community by some authority and applicable to its people, whether in the form of legislation or of custom and policies recognized and enforced by judicial decision. Now, these are just among the concepts that we will study in this subject, guys. Media laws and ethics. Now we proceed with the question, what is the Philippine Constitution? The Philippine Constitution, ladies and gentlemen, is the supreme law of the Republic of the Philippines. You have to bear in mind that all laws must conform to the Philippine Constitution. It's been said by one of the famous authors that the river should not rise above its fall, meaning when Congress makes laws, it must not violate or contravene the Constitution. Now, since the Philippine Constitution is a supreme law of the land, it is but proper to identify the constitutional provisions affecting the mass media in the Philippines. So first off is Article 2 of the Philippine Constitution, particularly Sections 24 and 28. Section 24, friends, actually states that the state recognizes the vital role of communication and information in nation building. Section 28, on one hand, provides that subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full disclosure of all its transactions involving public interest. Friends, Article 2 of the Philippine Constitution contains the Declaration of Principles and State Policies, and among these are the declaration on the role of communication and information in nation building, as well as the adoption and implementation of a policy of full public disclosure of all its transactions involving public interest, as provided for in Sections 24 and 28. Now we go to Article 3, the Bill of Rights. When we say the Bill of Rights, it actually guarantees civil rights and liberties of the individuals, like the freedom of speech, the freedom of press, and religion. And among the rights enumerated in the Bill of Rights are as follows. First is the Section 23 providing for our privacy of communication and correspondence. Section 23 actually provides that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Any evidence obtained in violation of this or in the preceding section shall be inadmissible for any purpose and in any proceeding. I'd like to discuss cases illustrating this particular provision of the Bill of Rights, ladies and gentlemen, starting off with the case of Zulueta versus Court of Appeals and followed by the case of Vivares versus St. Teresa's College. Now, first, I will show you the case of Zulueta versus Court of Appeals. So today, I will discuss Zulueta versus Court of Appeals. The issue here is the privacy of communication and correspondence between spouses. So, allow me to share with you first the facts of the case. So let's start off with the parties in this case. Ang parties here is the wife, Cecilia, and the husband, Dr. Martin. What happened is this. Cecilia went into the clinic of Dr. Martin. By the way, Dr. Martin is a doctor of medicine. So na siya clinic. And then Cecilia, the wife, went to the clinic of Dr. Martin, and there, in the presence of the secretary, the driver of Dr. Martin, and the mother of Dr. Martin, forcibly opened the cabinets and the drawers of Dr. Martin. Okay? So, pag open na niya, she got hold of at least 157 documents, allegedly a correspondence between Dr. Martin and his mistress. So, nadito ang mga love letters nila, ang mga greeting cards, mga diaries. In fact, there were also canceled checks. So, when Cecilia obtained these documents, she used it as evidence for the cases that she filed against her husband, Dr. Martin. She actually filed legal separation and then, I think, revocation of Dr. Martin's license to practice medicine. So Dr. Martin, upon learning all these, filed a case for the retrieval of these documents and that it actually belonged to him. It is his exclusive property and it should be returned to him and should not be used in evidence against him. Si Cecilia on one hand would interpose nga she is entitled to those documents because she is the wife of Dr. Martin, and that Dr. Martin could not interpose the defense that he has a privacy of communication and correspondence because he is already the husband of Cecilia. So it went to the trial court, and then the trial court decided that indeed the documents obtained by Cecilia were actually owned exclusively by Dr. Martin. So this is the reason why Cecilia went to the Supreme Court and questioned the decision of the trial court and the Court of Appeals. So the issue here really is, can these documents seized by Cecilia in this case be made admissible without violating the right of Dr. Martin to privacy of communication and correspondence? So, giunsa ka ni pagdesider sa Supreme Court. Here's the decision of the Supreme Court. Niingon ng Supreme Court, guys, nga indeed the documents and the papers in question are inadmissible in evidence. The constitutional injunction declaring the privacy of communication and correspondence to be inviolable is no less applicable simply because it is the wife who thinks herself aggrieved by her husband's infidelity, who is the party against whom the constitutional provision is to be enforced. The Supreme Court further said that the only exception to the prohibition in the Constitution is if there is a lawful order from a court or when public safety or order requires otherwise as prescribed by law. Ningon ng Supreme Court nga any violation of this provision renders the evidence obtained inadmissible for any purpose and in any proceeding. Ang pinaka-favorite gud nako nga part nga giingon sa Supreme Court in this case kay kani. Ningon siya nga the intimacies between husband and wife do not justify any one of them in breaking the drawers and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person, by contracting marriage, does not shed his or her integrity or his right to privacy as an individual, and the constitutional protection is ever available to him or to her. In fact, the Supreme Court, as a conclusion, said that the law ensures absolute freedom of communication between the spouses by making it privileged. But one thing is freedom of communication, quite another is a compulsion for each one to share what one knows with the other. And this has nothing to do with the duty of fidelity that each owes to the other. So there you go, guys. Mauna siya ang case Zulueta versus Court of Appeals. So in Zulueta, take note, guys, Hana, the Supreme Court said that the intimacies between husband and wife do not justify any one of them in breaking the drawers and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person, according to the Supreme Court, by contracting marriage, does not shed his or her integrity or his right to privacy as an individual, and a constitutional provision is ever available to him or to her. So all the more kita, guys, in the future when we practice our profession. Every time you feel like violating someone else's privacy, just think of the case of Zulueta versus Court of Appeals, okay? So now we go to the case of Vivares versus St. Teresa's College. This case actually stemmed here in Cebu City, guys, and here are the facts of the case. So they started when minors Ninita and Julian, along with several others, took pictures of themselves in underwear. They were actually smoking cigarettes and they were also drinking hard liquor. A third minor named Angela Tan uploaded them on Facebook. And then a computer teacher at the said minor school, ang sa St. Teresa's College, and the name of the teacher was actually Maylene, discovered the pictures. The pictures were reported to the discipline in charge and the girls were found to have violated the student handbook. So as a consequence, the students were actually sent to the principal's office where they were chastised and verbally abused. They were also banned from the commencement exercises, and on one hand, Angela's mother filed a petition for injunction and damages asking that the school be denied from prohibiting the girls from attending the commencement ceremony. A temporary restraining order was granted allowing the girls to attend the graduation, and the plaintiffs also filed a writ of habeas data alleging an invasion of their children's privacy by the defendant. The regional trial court in this case dismissed the petition for habeas data because, according to the RTC, the petitioners failed to prove the existence of an actual or threatened violation of the minor's right to privacy. So the primary issue here was whether or not there was indeed an actual or threatened violation of the right to privacy and life, liberty, or security of the minors involved in this case. Now, we have to remember that a writ of habeas corpus protects an individual's right against invasion of informational privacy, and a nexus between the right to privacy and the right to life, liberty, or security must be proven in order to be granted this relief. And in this case, the core issue was the informational privacy defined as the right of individuals to control information about themselves. Now, the question is, to what extent should the right to privacy be protected in online social networks, whose sole purpose really is sharing information over the web? Now, the petitioners in this case argued that the privacy settings on Facebook limit who can actually see what information is shared. This, according to them, gives users a subjective expectation of privacy. The court, on one hand, agreed. However, the court also ruled that before one can have an expectation of privacy in her Facebook information, he or she must manifest an intention to keep that privacy private by utilizing privacy tools. If someone posts something on Facebook and does not limit who can see that information, there is no expectation of privacy. The photos in the case at hand were all viewable by the friends of the girls or the general public. Therefore, according to the Supreme Court, the court ruled that the defendants did not violate the minor's privacy rights by viewing and copying the pictures on the minor's Facebook pages. So I hope that's clear. We now proceed to Section 4 and Section 7. Section 4 provides that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. Section 7, on one hand, provides that the right of the people to information and matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development shall be afforded the citizen, subject to such limitations as may be provided by law. Article 16, on one hand, particularly Section 10, provides that the state shall provide the policy environment for the full development of Filipino capability and the emergence of communication structures suitable to the needs and aspirations of the nation, and the balanced flow of information into, out of, and across the country in accordance with a policy that respects the freedom of speech and of the press. Now, I'd like to discuss Section 4 of the Bill of Rights, which is actually the basis for our exercise of free press and expression. Okay? Section 4 provides that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. This particular provision has two aspects or elements. First, the freedom from prior restraint, and the second is the freedom from subsequent punishment. Now, what is prior restraint? When we say prior restraint, this is a form of censorship that allows the government to review the content of printed materials and prevent their publication. This is not allowed in our jurisdiction, and this is an express prohibition in the Constitution. Okay? Now, what is subsequent punishment? It means that in order to make the freedom of expression clause of the Constitution more meaningful, there must be an assurance that after making any utterance or publication, the author is not subjected to any form of punishment. Now, the question is this freedom embodied in the Bill of Rights absolute? No, we have to remember that in every right, there is always an exception. There is always a limitation. And one of the limitations for this particular freedom is actually the principle or the rule on clear and present danger. When we say clear and present danger rule, this provides that abridgment of the liberty can be justified only when there exists substantial danger that the speech will likely lead to an evil which the government has the right to prevent. Now, this particular rule is actually illustrated in the case of Francisco Chavez versus Raul N. Gonzales in his capacity as the Secretary of Department of Justice and the NTC. This was decided in February 15, 2008, and here are the facts of the case. Sometime before June 6, 2005, the radio station DZMM aired the Garci tapes where the parties to the conversation discussed rigging the results of the 2004 elections to favor the then-President Arroyo. On June 6, 2005, Presidential spokesperson Bunye held a press conference in Malacanang Palace where he played before the presidential press corps two compact disc recordings of the conversation between a man and a woman. In this instance, Bunye identified the woman in both recordings as President Arroyo but claimed that the contents of the second compact disc had been spliced to make it appear that the then President Arroyo was talking to Garciliano. You remember the case of Hello Garci? However, on June 9, 2005, Bunye backtracked and stated that the woman's voice in the compact disc was not President Arroyo's after all. Meanwhile, other individuals went public, claiming possession of the genuine copy of the Garci tapes. Respondent Gonzales ordered the NBI to investigate media organizations which aired the Garci tapes for possible violation kuno of RA 4200 or the anti-wiretapping law. On June 11, 2005, the NTC issued a press release warning radio and television stations that airing the Garci tapes is a cause for the suspension, for the revocation, and or cancellation of the licenses or authorizations issued upon them. On June 14, 2005, the NTC offers to meet with the officers of the broadcasters group from the KBP to dispel the fears of censorship. So in this instance, the NTC and the KBP issued a joint statement expressing commitment to press freedom. So in June 21, 2005, the petitioner, in this case Chavez, a citizen, filed for a petition to nullify the acts, issuances, and orders of the NTC and the acts of the respondent Gonzales on the following grounds. Niingon si Chavez, the respondents here violated the freedom of expression and the right of the people to information on matters of public concern under our Constitution. And the NTC acted ultra vires when it warned radio and television stations against airing the Garci tapes. So the principal issue for resolution in this case is whether the NTC's warning embodied in the press release of June 11, 2005 constitutes an impermissible prior restraint on freedom of expression. Now, how did the Supreme Court rule on this case? The Supreme Court said this is a bit tedious, but for purposes of really understanding this particular freedom, we have to go through the decision of the Supreme Court. And as the Supreme Court said, freedom of expression is the foundation of a free, open, and democratic society. Freedom of expression is an indispensable condition to the exercise of almost all other civil and political rights. Freedom of expression allows citizens to expose and check abuses of public officials. Freedom of expression allows citizens to make informed choices of candidates for public office. Article 4, the Supreme Court reiterated that the Constitution prohibits the enactment of any law curtailing freedom of expression. Niingon pa gani kuno ang Constitution nga no law shall be passed abridging the freedom of speech, expression, or the press, etc., etc. Further, according to the Supreme Court, the government action in the present case is a warning by the NTC that the airing or broadcasting of the Garci tapes by radio and television stations is a cause for the suspension, the revocation, and or cancellation of the licenses or authorizations issued to radio and television stations. The NTC warning embodied in a press release relies on two grounds, according to the Supreme Court. First, the airing of the Garci tapes is a continuing violation of the anti-wiretapping law and the conditions of the provisional authority and or certificate of authority issued to radio and TV stations. Second, the Garci tapes have not been authenticated and subsequent investigation may establish that the tapes contain false information or willful misrepresentation. The Supreme Court continued that the NTC does not claim that the public airing of the Garci tapes constitutes unprotected expression that may be subject to prior restraint. The NTC does not specify what substantive evil the state seeks to prevent in imposing prior restraint in the airing of the Garci tapes. The NTC does not claim that the public airing of the Garci tapes constitutes a clear and present danger of a substantive evil of grave and eminent character that the state has a right and duty to prevent. The NTC did not conduct any hearing in reaching its conclusion that the airing of the Garci tapes constitutes a continuing violation of the anti-wiretapping law. There is also the issue of whether a wireless cellular phone conversation is covered by the anti-wiretapping law. Clearly, the NTC has no factual and legal basis in claiming that the airing of the Garci tapes constitutes a violation of the anti-wiretapping law. The NTC concedes that the Garci tapes have not been authenticated as accurate or truthful. The NTC also concedes that only after a prosecution or appropriate investigation can it be established that the Garci tapes constitute false information and or willful misrepresentation. Clearly, the NTC admits that it does not even know if the Garci tapes contain false information or willful misrepresentation. The NTC press release threatening to suspend or cancel the airwave permits of radio and television stations constitutes impermissible pressure amounting to prior restraint on protected expression. Whether the threat is made in an order, regulation, advisory, or press release, the chilling effect is the same. The threat freezes radio and television stations into deafening silence. Radio and television stations that have invested substantial sums in capital equipment and market development suddenly face suspension or cancellation of their permits. The NTC threat is thus real and potent. As a conclusion, the NTC press release constitutes an unconstitutional prior restraint on protected expression. There can be no content-based prior restraint or protected expression, and this rule has no exception. I hope you guys learned something from this lesson. If you have questions, you may send me a private message or you may drop them in the comment section or you may chat me in our Teams class. Thank you very much. I'm Ping.